About California courts and ex post facto laws. First, what is an ex post facto law? The phrase comes from from the Latin language that basically means after the fact, and it's used to describe when a law is changed retroactively to capture previous conduct and subject that conduct to legal consequences. Ex post facto laws are generally prohibited by both the federal and state constitutions because otherwise these types of laws would make people criminally liable for conduct that was not unlawful at the time that they had occurred. The U.S. Supreme Court has held that people must be aware of the possible criminal penalties for their actions at the time that they act. California courts have explained that a statute must do one of three things to be an ex post facto law. First, it must criminalize an act previously committed which was innocent when it was done. Two, it must increase the punishment for a crime after its commission, or it must withhold a defense available according to the law when the act was committed. This was set forth in 1990's Collins versus Youngblood case and Tapia versus Superior Court by the California Supreme Court. In one appellate court decision, the judiciary said that this individual, the defendant, was subjected to the exact same statutes which were in effect at the time that his property was seized and forfeiture proceedings began. And so he cannot claim unfair surprise or vindictive government action. This was People versus McVickers in 1992 by the California Supreme Court. In People versus McKinney, the court said that restoration of an original punishment in effect at the time the offense was committed was not unjust or unfair. Now, some have also argued that ex post facto laws implicate the Equal Protection Clause of the 14th Amendment to the U.S. Constitution. In this regard, one appeals court in California explained that the 14th Amendment does not forbid statutes and statutory changes to have a beginning and thus to discriminate between the rights of an earlier and later time. This was a 1984 Cal Supreme Court decision in Baker versus Superior Court. So in Baker, the petitioners challenged their continuing commitment under the mentally disordered sex offender statute. The legislature had eliminated this program following these individuals' initial commitment to a mental facility. They alleged a denial of equal protection in that they were subject to indefinite commitment, but MDSOs convicted under new laws would receive a determinate prison sentence. The court said the court determined equal protection principles do not require that all persons who commit the same offense suffer the same consequences regardless of the date of their misconduct. Rather, the legislature may properly specify that statutory amendments and additions are prospective only. Such laws do not violate equal protection principles. See also Government Code Section 9606, which specifies in California state law any statute may be repealed at any time except when vested rights would be impaired.